arbitrationagreements.org. Welcome to an exploration of an effective and innovative solution to resolving employment disputes, alternative dispute resolution, also known as ADR. Before we get started, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save you a great deal of time and money. According to the National Center for State Courts, a mere 20% of civil cases went to trial last year across the USA. That number has been dropping for decades. Why? Because an increasing number of disputes are being settled outside the courtroom using methods like ADR. ADR provides an environment for conflict resolution that is less formal, more flexible, and typically more cost-effective than traditional litigation. When it comes to employment disputes, ADR can be a game changer. Employment disputes often involve conflicts between employers and employees. These could be related to discrimination, harassment, wrongful termination, wage disputes, or workplace safety issues. Traditional litigation for these disputes can be lengthy, complex, and expensive for both parties. ADR methods like mediation and arbitration, on the other hand, present an alternative path that is often quicker and less adversarial. In mediation, an impartial third-party mediator assists the disputing parties in reaching a voluntary, negotiated resolution. Mediation is non-binding, meaning the parties are not obligated to accept the outcome unless they agree to it. Arbitration is another form of ADR, where an arbitrator or a panel of arbitrators listen to the arguments presented by the disputing parties and then make a decision. This decision can be binding or non-binding, depending on the agreement made prior to arbitration. In the world of employment disputes, ADR has been found to preserve the employee-employer relationship. The collaborative nature of mediation and the fairness of arbitration often lead to outcomes that are mutually beneficial. This allows the working relationship to continue, which is a key advantage over litigation where winning often means severing ties. ADR is not just about resolving disputes, it's about transforming the way we view conflict and how we manage it. It focuses on creating channels of communication and finding common ground, even in the midst of disagreement. So next time you face an employment dispute, consider ADR as a viable solution and experience the benefits of this alternative approach to dispute resolution. Do you need tools or resources for resolving employment disputes? If so, head over to arbitrationagreements.org. That's where you can buy the service or program you need right away and begin the dispute resolution process quicker. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you're interested in doing that as a business, we are standing by. Also, what do you think about ADR? Does it seem like a potential solution for resolving an employment dispute? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.